Hello, what's up? Once again, we live. Today I'm going to talk about Sean Grayson. We're going to talk about Sean Grayson's prior behavior more than anything. And the consequences of his prior behavior, as we know, was Sonia Massey. She lost her life. So let's not waste any time and let's get right into it. So what do we know about Sean Grayson? One of the things we know about Mr. Grayson is that he had a criminal record. And let's take a look at it. DUIs and integrity concerns of Mr. Grayson. So what we clearly know is that Mr. Grayson was not a stand-up officer. And let's just go right to it. Grayson let go from the Army after serious offense. Grayson was discharged from the Army after misconduct, described only as a serious offense. Now, people, we don't know what that serious offense was. We'd love to know. I'm sure there's federal laws and privacy laws in place that do not allow us to know. But that could have been enough for these multiple police agencies that chose to employ Mr. Grayson to say, no, we don't have a spot for you here. Whatever it is, it was enough for the Army to let you go. We don't want you patrolling our streets in our community with our citizens. Because as we can clearly see, something seriously bad could happen to a person. While Grayson was in the Army, he was charged with driving under the influence, August 10, 2015. Grayson's former first sergeant, in writing a recommendation letter for him at a job at the Auburn Police Department, noted that aside from Mr. Grayson's DUI, there were no other issues that he had during his tenure in the Army. So we can see somebody thought he was okay to seek employment outside of the Army. Now, should they have explored that more? Hindsight being 2020, we can all say yes. But the truth is, Mr. Grayson just was a bad guy, and he slipped through the cracks, and the cracks have resulted in this beautiful young lady losing her life. What else we know about Mr. Grayson? What else do we know about Mr. Grayson? Grayson pleads guilty to 2 DUIs before he was hired by law enforcement. So what do we know? What does this tell us? This guy is a rule breaker. This guy has no respect for the law. This guy has no respect for other human life. And we're going to employ him, give him a gun, put him on the streets to protect and serve. It just was a bad idea. He should have never been allowed to serve as a police officer. So let's read on. Asked on the employment application for the Auburn Police Department if he had ever been convicted of, charged with, or currently waiting trial for any crime greater than a minor traffic offense, to include driving while intoxicated. Grayson answered, no, I have only been arrested and charged with DUI. I don't see any problem with that. I don't believe he was dishonest. That was up to Auburn Police Department and everybody else that hired him after that to, to use their discretion in deciding if he was somebody that needed to be serving on the streets in their community. So what else do we know? Mr. Grayson lying, abuse of power during previous law enforcement stints. Grayson worked at 6 different law enforcement agencies in 4 years, according to his personnel file and the Illinois Law Enforcement Training and Standards Board. During his first year as an officer, Grayson bounced around 3 central Illinois police departments in Pawnee, Kincaid, and Verdun. His time at several of the agencies overlapped as he's worked part-time before obtaining a full-time position at the Auburn Police Department. So let's break that down. Number one, as I've said before, and many of you know, the pay law enforcement. Look, it's a highly respected profession. It's a much needed profession, but it's kind of like being a school teacher. It's vital to our way of life. However, the pay just is not that great. So he wasn't paid a significant salary, I would imagine, which is probably why he worked at 3 different, which is why his time at several of these agencies probably overlapped. The guy just needed the extra money. Now, with that being said, that means there was several different opportunities for several agencies to press pause or say no to employing him, especially knowing his prior history. So what else do we know? In May 2022, Grayson went to the Logan County Sheriff's Office before he was hired by the Sangamon County Sheriff's Office a year later. While at the Logan County Sheriff's Office, a supervising officer rebuked Grayson for allegedly lying in reports and showing a general lack of integrity, according to a recording obtained by CBN News. So, as we know, whoever this supervising officer was, he doesn't know who he was dealing with, because this guy is not to be rebuked in the name of Jesus or for any reason. The sheriff and I, look at what this supervisor said. The sheriff and I will not tolerate lying or deception. The officer can be heard telling Grayson, later adding, officers like you have been charged and they end up in jail. Now, kudos to this supervisor. I wish I knew who he was. I wish I could bring him on this live stream to tell the public why he went in so hard on Grayson the way he did and why he believes that was necessary in that moment. And, the profession he's in, why it's so important for officers to have integrity, honesty, and respect members of the public. So what else do we know? Grayson was also accused of abusing his power and harassing a couple he pulled over and arrested during a traffic stop. Citing a disciplinary file from the Logan County Sheriff's Office, the file noted that the allegations by the couple against Grayson were deemed unfounded. So this is what happens, people. It happens over and over and over and over again. These officers, they start out, the bad officers, they start out, they abuse their power, they're rude to people, they curse people out, they mistreat people. And I'm not just saying that, just pulling that out of a hat. It's happened to me. It's happened to me more than once. And I'm about as nice and calm and easygoing and respectful as a person can be. And I remember being cursed out by a police officer when I was a teenager. I think I was walking to the store to buy something for my grandmother, and this guy passes by. I'm walking alone, stops his car, tells me something like just rude. I kind of scared, nervous. I just keep walking. I mean, I don't have any weapons on me. I don't have any drugs on me. That's not something I did. I played sports and went to school. But, he did that to me. So who knows who else he did that to during his time on the police force at the Simsport Police Department. But back to Mr. Grayson. He apparently a couple made a complaint. Of course, it was deemed unfounded. There probably was no body cam of that complaint. We know Mr. Grayson doesn't believe in turning his body cam on, and that those allegations went unaddressed, undisciplined, and I'd imagine we're going to learn about many other instances where Mr. Grayson abused his power and it progressively got worse until ultimately this lady was murdered. That's it. She was murdered. There's no other explanation for it. It was cold-blooded murder. So what else do we know? Gerard Police Chief Wayman Meredith told CBS that last year Grayson pressured him to call child service on a woman outside the home of Grayson's mother. Meredith described Grayson as steaming mad, and said he'd flagged the incident to the Logan County Sheriff's Office. He was acting like a bully. Oh, what a surprise. Meredith told the outlet, speaking about Grayson, he was wanting me to do stuff that was not kosher. So another chance. He harasses this couple. They report him. Nothing happened. The Girard police chief says, something's wrong with this guy. He's a bully. He's aggressive. He wanted me to do stuff I should not be doing as a law enforcement officer. And he reported it. And what happened? Nothing. So this is where we need accountability, people. When these incidents happen, there needs to be vigilance in dealing with the officer. Look, get him help, get him counseling, suspend him, fire him, do whatever the heck needs to be done so innocent people aren't injured or killed, which is ultimately what happened in this case. This guy was a ticking time bomb. He was a ticking time bomb, and people around him knew it, noticed it, even reported it. Nothing happened until the you-know-what hit the fan. Didn't have to happen, people, and we can do better. So what else? Here we go, of course. The sheriff's office, Sangamon, the Sangamon County Sheriff's Office said in a statement that it was not provided with any information regarding Grayson's alleged dishonesty or misconduct. During his time at the Logan County Sheriff's Office, we were not providing any such information from any of Grayson's former employers, nor from any crediting agency. We cannot comment on whether the information is accurate, nor why it was not shared by another agency. So when I hear stuff like that, people, all I can say is, you do not get to stick your head in the sand like an ostrich when you're putting people on the street to protect and serve, giving them a firearm, authorizing them to use it when appropriate. You don't get to stick your head in the sand when it comes to doing a thorough background, making sure this person is qualified, mentally stable and competent to go out and do the job. It's a dangerous job, but it's dangerous for the officer. But if you have the wrong person serving as an officer, guess who it's dangerous for? You, me, everybody. It's dangerous for the public. So the fact that the Sangamon County Sheriff's Office wants to be an ostrich here and stick their head in the sand and say, oh, we didn't know, nobody didn't tell us. You're the sheriff's office. Do a thorough background on this guy. Do a thorough investigation as if you were investigating a crime. And you should do that with all officers, all of them, every last one of them. That's one thing we can do to limit, this kind of person ending up on our streets, endangering the public instead of protecting and serving. So I want to go to some of the videos that were released concerning Mr. Grayson, and we're going to dive into him a little bit. So here we go.
Department of Justice and a Springfield church will host a community healing and listening session, giving friends and neighbors a chance to mourn the loss of Sonia Massey.
The Springfield mother was shot to death by a now fired sheriff's deputy after she called 911 for help. Meanwhile, our Dave Savini has uncovered new details about that officer's past. And Dave, there are serious questions about why he was hired multiple times.
Erica and Joe, CBS News has uncovered notes from one of Grayson's former police chiefs during a reference check for his next police job. It was a warning of the trouble Grayson had already caused, and it doesn't stop there. Another supervisor said he failed to obey orders, especially during the high-speed chase you're about to see.
The red flags and warning signs were there prior to Deputy Grayson firing those fatal shots into Sonia Massey.
I'm trying to get help.
A woman home alone who called police for help over a possible intruder, but instead ended up with Deputy Sean Grayson.
What?
Grayson, who's now charged with her murder, had a troubled career that began with a stint in the Army, a discharge for misconduct, then followed by more accusations of misconduct.
We checked your front yard.
During his time in law enforcement, described as having trouble obeying orders.
We're at the end of 2nd Street. She's taking a right.
Like with what happened here at his 5th police job when he refused an order by a superior at the Logan County Sheriff's Department to terminate a high-speed chase over a traffic infraction. His speed at times reaching 110 miles per hour.
Are you pursuing?
I'm about to terminate. She's flying up 121 right now.
But Grayson didn't stop. He did, however, turn off his lights and siren, but kept going anyways until he hit a deer.
Well, I'll definitely be terminated because...
Look at this. Look at this guy. It's not just that he did this and was fired from this job. It's that he was hired other places. This guy is speeding, he was given a direct order to stop. What does he do? He turns off his siren. He turns off his lights. Now, what happens to me? What happens to you if we're driving down the road, speeding 100 miles an hour, and we turn our lights off? What happens to us? How is he any different? How is he special? How did he deserve to ever work in law enforcement again after that behavior? I would love to answer that. I don't have any answers. Other than me or you, we'd go to jail. We'd probably lose our private job in the private sector because of that. We may even lose our driver's license for a while. Now, Mr. Grayson, he should have been terminated, no doubt about it. And I believe he was. He was terminated from this job. That's not the problem here. He should have never been allowed to work in law enforcement again. He killed a deer and one of God's innocent creatures. He could have killed a person or persons or many people. Anybody on the road that night could have died, could have been this guy's victim. Why didn't Sangamon County know about this? I do not know. But if whatever the reason is, it's inexcusable. If there is a rule or a privacy right that prohibited them from knowing about it, then the state of Illinois needs to carve out an exception when it comes to law enforcement jobs and why a person was terminated from a prior job. Anybody that's put in a position of power that could potentially endanger members of the public, as part of the job, you should be willing to give up certain privacy rights, especially when those rights allow you to go out and continue to be a danger to society. I do criminal defense work. My clients who are convicted felons, they don't get to hide that. They don't get to not disclose that on their job applications. Even if they get it expunged, if they're applying for a job with a state agency or a government entity or a law enforcement agency, guess what? Or the doctor's licensing board, a pharmacy licensing board, if a person has a convicted felon, even if those charges have been expunged from their record, there are still certain government agencies that can see those convictions. Why should police be any different? Why? They shouldn't. Absolutely not. So let's see what else happens on this video.
As a buck just smacked the side of my driver's side door.
Did you violate a direct order from a supervisor about termination?
Yes, I did.
Grayson was questioned by a deputy chief and other top staff after that crash in Logan County.
Do you agree, before we conclude this, that there's a mountain of policy violations
Yes, I did.
that you committed? 7 months on, how are you still employed by us?
I don't know.
Yet he continued to get a pass over and over again. Even during the Logan County hiring process of Grayson, there were warning signs from another past employer, the Auburn, Illinois Police Department, where he worked in 2022. CBS News obtained these notes from a discussion between the Auburn chief and a representative from Logan County, where Grayson had applied for a new job. It states the Auburn chief said Grayson struggles with report writing, that he was very aggressive with getting drugs. The chief expressed concern that Grayson was too aggressive and that Grayson posted his drug arrests on Facebook, and the chief called him a bragger and was not great with evidence, left items laying around office.
The entire thing makes me sick.
Sangamon County board member Mark Ayers is on the jail committee that authorizes the hiring of new sheriff deputies. He says he was never informed of any negative notes about Grayson prior to hire, and his background was not shared with the committee.
I would never bring on someone that had that troubled past or that record.
As we have been reporting notes from one of Grayson's former police chiefs during a reference check.
Member Mark Ayers is on the jail committee that authorizes the hiring of new sheriff deputies. He says he was never informed of any negative notes about Grayson prior to hire, and his background was not shared with the committee.
I would never bring on someone that had that troubled past or that record.
As we have been reporting, Grayson worked for 6 police agencies since 2020, ending with Sangamon County, where he was entrusted to help residents in need like Sonia Massey. Board members Ayers said he wants changes in the hiring and screening process, along with a background review of all current sheriff deputies.
So there we go. Why wouldn't this be disclosed to Mark Ayers? You know, this guy was in charge of making sure the officers who are hired or were hired were competent to do the job and were not dangerous. And for whatever reason, he wasn't informed. Look, that needs to be changed. That needs to be changed in Illinois and anywhere else where it's a problem. Otherwise, we'll continue to run into situations where innocent people are murdered. It's nothing else to call it. This is a murder. He's where he should be. Hopefully he remains. Because at a minimum, there needs to be a lesson there and a message sent to other bad actors, bad officers who subscribe to the mentality of Sean Grayson. So let's see what else we learned since this all occurred.
We're learning new details about the former deputy who was fired after the deadly shooting of a black woman in Illinois. Sonia Massey called 911 saying she suspected a possible intruder outside her home. Body camera video shows deputies responding to Massey's house. Shots were fired after she picked up what appears to be a pot of boiling water from her stove. The family says Massey was unarmed. The former deputy, Sean Grayson, has pleaded not guilty to charges, including first-degree murder. He was arrested and remains in custody. Now, new original reporting from NBC News finds Grayson worked for 6 law enforcement agencies since 2020. That's according to Illinois law enforcement records, and even had his own previous run-ins with the law. NBC News national reporter Janelle Griffith is behind this new reporting. So, Janelle, walk us through what exactly you found.
So there we have it, just a history of more talks about the history of alcohol abuse. I'm actually less concerned about that than I am about the fact that there were reports of mistreatment of other members of the public that were, it appears nothing was ever done about it. And there was reports of him violating policies of agencies he worked for, like blatantly ignoring direct orders, and especially in the high-speed chase where he turns the siren and lights off and is driving in the dark and hits a deer. You know, this guy, I don't understand why this guy should ever be allowed to continue. I got a guest joining, folks, so we're going to stop for a moment and bring him on. Here we go. Gotta shrink you. How you doing, Mr. Daniels? Can you hear me?
Yeah, I can hear you. I got some special guests in the room with me. Got Avery and Hope joining us, remotely, kind of on daddy duties as we do this.
So for those of you who don't know who this is my law partner, Harry Daniels. What you doing, Avery? Say hey to your favorite uncle. All right, so right now we on these, I'm going to run through this video right here, Harry, that we have with the Mr. Grayson's. I'm having a little technical difficulty here with this video, but
Records show the former deputy who shot Sonia Massey worked for multiple departments in the state of Illinois in just a handful of years. Senior investigative reporter Paula Vassan delves into how law enforcement officers in the state of Illinois are tracked. Paula.
Well, legal experts tell us the state of Illinois has something Missouri does not have, a way to search for police officers to check their work history. It shows former sheriff's deputy Sean Grayson worked for 6 different agencies in the state of Illinois in just 4 years. But the public website does not show the full picture, revealing hired and separation dates without explanation. State records show 30-year-old Grayson hopped around as a part-time officer at 3 small departments. He had a full-time job at a 4th department and worked at 2 sheriff's offices.
I'm going to pause right here. Let's just talk about this, Harry. What do you think about this? The fact that he had all these different jobs. What is over a 6-year period? No. Over a 4-year period.
I think what happened is probably he had all these different jobs, and probably what happened is every time he was getting in trouble or he was on the verge of some kind of misconduct, what he probably did was he probably just went quit that job in lieu of being fired. A lot of police officers do that. So in order not to be fired and have them being fired for the misconduct or the bad act that they committed, they just simply resign, and then they go to another local agency or another agency, maybe in the same city, maybe the next city or the next town over, and then they start the same bad conduct again, and then it just repeats itself over and over again.
You know, you've been practicing law over 17 years. Is that right? 16, 17 years?
Yeah, 17 years.
And is that common? Like, is what we see with Mr. Grayson, is this just a one-off or just a random occurrence with all these different jobs, or is this something you frequently see in your own practice?
No, I think it's something that's it's something that a lot of rogue or bad officers how they conduct business. You know, I was on the de-escalation task force here in Louisiana before, and that was an issue. Is that when somebody commits a bad act, there's no real way for the misconduct to follow. But I think, from my understanding of Mr. Grayson's case, actually in this particular area, they actually had an ability to track these bad officers. However, through connections or just overlooking of the bad acts, he was able to still get jobs. So I think a bad officers, they generally just resign to avoid being fired and have that in their personnel file. And if somebody calls, there's really no way and I think there's some rules against disclosing somebody resign as opposed to being fired. So I'm sure he's playing that game and moving around a lot.
So I gotta ask this, and are the citizens of Louisiana at a threat of encountering a Sean Grayson based on the current structure of our law enforcement with respect to background checks and making sure these officers are not a threat?
So I believe so. So there's two ways to combat that. Louisiana, I guess the agencies that regulate police officers is called Peace Officer Certification. There are board, and every police officer has what's called post certified. And a lot of times what happens is if an officer resigns, if an officer doesn't have a felony or misdemeanor conviction, there's no way for the post certification to even affect their certification because they're not putting notice that this officer has committed misconduct. Because of course you have the blue wall. Police officers generally stick together. There are a lot of good officers, but there are also some bad officers. And in this case, Louisiana citizens are in danger of it because there's really no way to track these bad officers when they commit misconduct because they just move around a lot and there's no way really to track them unless there's some rule or law enacted that, even if an officer isn't, I guess, fired or charged with a felony offense or a misdemeanor offense, there should still be some checks and balances in place to follow these officers around so the public or their new employer, who would be a police station or a sheriff's office, could be aware that this officer has some issues in the past. And they could, I guess, exercise some form of patience or pause when considering whether or not to hire this particular individual.
Well, let me ask you this: what stops a sheriff from, let's say, if a sheriff from East Baton Rouge wants to hire an officer, and the officer formerly worked in West Baton Rouge, what's stopping that sheriff from calling the other sheriff to say, "Hey, what happened with this guy? Why'd you let him go? Why is he no longer working there?"
I don't really know the answer to that question. I would assume they could, but I would assume that most sheriffs don't. They have a human resource department that I would assume that's kind of in charge of that, gathering that information to put the sheriff on notice. But I don't think, I'm unaware of any rule that would prohibit another chief of police or another sheriff's office from calling the other agencies to find that information out.
Do you think it would be difficult to set up some kind of database that was limited to only law enforcement agencies, that required law enforcement agencies to indicate the reason why an officer no longer worked for them, and allowed future employers only in law enforcement to see the reasons?
No, I think there's databases for everything. There's a train on database that law enforcement can determine whether or not somebody has a previous or a current restraining order against them. There's also databases to determine whether or not somebody is a felon, to quickly run their background check. There's all sorts of checks and balances in place, but the issue is law enforcement would have to, someone, either the governor or somebody high up would have to make a decision that this information is important and needs to be monitored and kept, and a record needs to be made of it in order for this information to be made available when considering hiring decisions. In fact, I think there's actually, not to cut you off, I think there's actually a database that was recently installed in Louisiana to what's called a Brady database, or a database that helps people be aware of officers that have been accused of misconduct or found guilty of misconduct, whether it's on the civil side or the criminal side. I think it's called a Brady database. I think the Innocence Project, along with some other groups, have that database, and they add officers as they've been given information. But I think the problem here in Louisiana is you have a lot of smaller and rural areas that don't necessarily add that information or keep that information up to date in order to make the public aware and also make the employers aware that this particular officer has some misconduct, whether it's a felony charge, whether it's excessive force, or whether it's some allegations of being untruthful in some reports, and that sort of thing.
All right, so it sounds like we need something in place to police the police, at least the ones that are going out committing crimes.
You say what now?
It sounds like we need something in place to police the police, at least the ones that are going out committing crimes.
Yeah, so like I said, back in, I think in 2021, the former Governor Edwards had convened this, what's called a de-escalation task force, and I was part of that. And that was one topic kicked around, but that issue never even made it as a task force, because there was a lot of opposition to it, because they alleged that there was some kind of violation of federal employment laws if that database exists, or if that information was put in officers' files, that it presented potential lawsuits if that came about. I disagree. I think in every other industry or in every other walk of life, people are denied employment for various reasons of prior acts, whether it's on another job or whether it was when they were a kid or for whatever reason. So I think that database would be very easy, and the police officers are working in the public. So I think it would be necessary in this case to stop the Sean Graysons of the world from going around and around and just avoiding I guess getting fired or avoiding consequences by just simply going to another agency. I could think of even as close home in Louisiana. I know a few officers that had got in trouble at the Iberia Parish Sheriff's Office. They left there, they went to Youngsville, or they went to General Police Department, or they went to Baldwin's Police Department, and they kind of just cycle around. I could think of a few officers off the top of my head that they just do that. They get in trouble, written up for some kind of misconduct, whether it's lying in their police report, maybe using excessive force. They get sued in federal court, and in lieu of getting fired, they resign. And a couple months later, a couple weeks later, they pop up in one of these smaller police agencies and have a job and go right back on the street. When in the other town, 5 minutes over, they have some issues that they testify because their testimony may not be believed because they may have lied in another police report or had some other kind of nefarious act that they did.
All right, that's good. That's good. So let's continue on through this video.
All of his jobs in central Illinois. We've also discovered he had 2 misdemeanor DWI convictions in Macoupin County. The I-team is working to find out what's being done in the state to prevent officers with potentially bad track records from bouncing around. Industry sources tell us it's the responsibility of the Illinois Law Enforcement Training and Standards Board to allow an officer to be hired somewhere else. The I-team has reached out to that board for an explanation into how Grayson kept getting hired. We're waiting to hear back. We've also discovered that in general, sovereign immunity in state law often prohibits negligent hiring cases against state entities like police departments. It means it can be easier for bad hires to slip through the cracks.
If you have a tip for Paula, call 314-4.
Today, not tomorrow, not next week.
All right, I don't know what's going on with this video. Let me see if I can get it to play.
Illinois Fraternal Order of Police is calling for the reinstatement of former Sangamon County Sheriff's Deputy Sean Grayson. He's currently in jail on first-degree murder charges for shooting 36-year-old Sonia Massey in her home after she called 911 earlier this month. Our Captain Bureau Chief Cole Hinkey has more.
The grievance was terminated without just cause. That's the first.
So what are your thoughts on this? Obviously, they're saying he was terminated without just cause. And I'm going to read the statement. The grievance was terminated without just cause. Further, the employer publicly disseminated details of the investigation and termination on Facebook in violation of the CBA collective bargaining agreement, and prior to giving the grievance or his representatives notice of the decision to terminate. Remedies are reinstatement and reimbursement of all lost wages, restoration of all lost benefits, and any other appropriate relief. So, what are your thoughts on that? I can't hear you.
I think it's definitely a loophole in the law. I think this seems like the police union stepped in and said the chief, whoever fired Mr. Grayson, in some capacity or some form, violated some administrative rule. Therefore, Mr. Grayson was not only given his job back, he also was given full reimbursement for all money that he lost during that time period. So in this particular case, I would assume it seems that Mr. Grayson was a member of some kind of police union in Illinois or sheriff's union, whatever law enforcement he was working for. And they stepped in and said, well, you fired him and you violated some rules because you put the public on notice that he had did these bad things prior to, putting him and his representative on notice. And I guess his representative, at most hearings when you have a law enforcement go before the board for a termination hearing, they can have a legal counsel present. So it seems like the chief or sheriff violated some administrative rules, and Mr. Grayson got the benefit of it and was allowed to get back on the street and get his gun back.
Yeah, it sounds like there's some due process rights that were in place that Mr. Grayson was entitled to, and I'm all for individuals being given due process under our laws. However, as we all know, our rights our rights have to come secondary a lot of times to what's in the best interest of the community as a whole and public safety and national security. So we routinely subjugate some of our rights to the government in the interest of our society as a whole. So whatever due process rights Mr. Grayson was entitled to, I'm sure as they go through the process, his termination would be upheld. Certainly, nobody should expect him to be reinstated, paid, and put back on the street. That's just absurd, but I understand he has these rights. Hopefully, they can expedite the process and be done with it. So the last thing I want to talk about today with respect to Mr. Grayson is really Sonia Massey's son and what he had to say about all of this. So I'm going to go ahead and play
I find that a lot of my work that I do on a day-to-day is equivalent to what I learned at.
The shooting of a black woman inside her own home is sparking national outrage this morning. Sonia Massey, a 36-year-old black woman, was gunned down by...
This is a nice little video. It's about 8 minutes long, but this is we get to hear from Sonia Massey's son. So let's hear his thoughts and what he thinks should happen to Mr. Grayson.
deputy after she called 911 to report a possible prowler at her home. She called for help and ended up dead. She was shot seconds after police had given her to remove a pot of boiling water from the stove. The officer then drew his gun, causing her to duck for cover. She was shot 3 times in her own home. Now her family is demanding to know why the deputy who pulled the trigger was hired in the first place. His personnel file revealed a troubling employment history and past DUI charges. I am joined now by Sonia's son, Malachi, and civil rights attorney Ben Crump, who is representing the Massey family. Thank you both for coming in this morning. I know, Malachi, that you are heartbroken. Can you tell me first how you found out that your mother had been shot and killed?
So basically, I take my dad to work at like 5 o'clock in the morning or whatever. So I was taking him to work. I came home, then I was getting back in the bed. And as soon as I had woke up, not even woke up, I'm sorry. As soon as I was finna go back to sleep, I got a call, and it was a random number. I didn't know who it was, but I answered it. And that's when they said, your mother has been shot, and it came out her neck. And it went through her eye, and it came out her neck. And they just was saying somebody. That's all they, I don't know why they kept on saying somebody shot her. And I said, who? And they wouldn't tell me who. I'm like, who? And they just said somebody. And then next thing you know, I get up. I wasn't even thinking. I was like, I got to get to my grandma's house. And then I told my grandma what happened, and she was just in disbelief. Just like me, I didn't want to believe it. And then we didn't find out that it was a police officer until a day after, too. That's the thing. So we were just left clueless, honestly.
What do you think should happen to the officer? I know that you have told me that you have not watched the video, which would be so traumatic for you. So that's but what do you think should happen to the officer who took your mother's life?
I think he should be, man. Honestly, he need life, or something, because it's no way in the world that should have happened to my mother.
All right, I think that's good enough. I heard him say he need life. What do you think about that? I can't hear you.
I think based on what I saw in the video, I didn't see Miss Massey posing any threat to either of the officers. I'm not sure what triggered this Mr. Grayson off. From what I can see in the video, when you slow the video down, Miss Massey had 2 arguments in her hand, and I agree with her son. I think he should have a life sentence based on his actions. It was a cold-blooded murder. Miss Massey basically just told him, a religious quote, and I don't know if that triggered him, but I don't know what triggered him, but there was no danger in him. That pot never left off of the counter from what I can tell, and Miss Massey actually got on her knees begging not to be shot. With 2 arguments in her hand, ended up dead as a result of it.
Well, one of the things she said to him was, "I'm sorry. I'm sorry." Her comment was, "I rebuke you in the name of Jesus," and what she actually said to him was, "I'm sorry," and he ended up shooting her. There's some reports he's claiming, she had a pot of hot water. He didn't want to be burned by hot water. She was maybe about 10 feet away from him. The fact that she had a pot of boiling water, which in fact, if you look at the earlier videos, he instructed her to take it off the stove. But past that point, the fact that she had a pot of boiling water and was approximately 10 feet away from him as a criminal defense lawyer, do you think you could reasonably argue justifiable homicide by Mr. Grayson?
I think in this case it's going to be hard for Mr. Grayson to argue that he was justified in killing Massey based on his reasonable belief that he was in danger. As you pointed out, he instructed her to take the pot off the stove. She placed the pot on the counter. At some point, he said something, and she said, "I rebuke in the name of Jesus," and then he cursed her out. And then Miss Massey backed away from the counter, although the pot is within the arm's reach. She didn't have the pot in her hand. She actually kneeled on the ground, and then she was shot. So I think it's going to be he's going to have a very hard time convincing 12 people that he acted within reasonableness of a police officer. Now, of course, they're going to argue and say that this police officer, he was in a high stress situation, and I'm sure they're going to, come with something else and say, maybe he had PTSD from some earlier event in his law enforcement career that may have triggered him. But I don't see self-defense or reasonableness or justification in this particular case for Mr. Grayson.
So, thank you for coming on and providing commentary. That was very much needed. Actually, it's no fun being on here solo, but sometimes you got to do what you got to do. So, one of the things you originally agreed to come on for was to talk about all the new laws that are, taking, some of the new laws, not all of them, but the laws that are taking effect today that are very important to members of the public. So I want to jump into that if you're ready to go. You ready?
Yeah, we're going to jump into it right now.
All right, let me pull it up. I'm going to put... let me bring you on right here. Let me see if I can make this a little bigger without actually. All right. You got it? You can see it?
Yeah. So this is one of the new laws that goes into effect today that our new governor enacted via, I believe, a special session when he came back, when he first took office to get tough, what he calls being tough on crime. So this new law, basically, anybody convicted of a crime from August 1st, any crime committed August 1st moving forward, if you're convicted of a crime, now you have to do 85% of that sentence. So let's say, you get a 10-year sentence. That means you have to do 8 years and 85% of it. Probably 8 years, 5 months, somewhere in that area. So
85% of all sentences moving forward must be served, right?
Yes, and that's definitely a big change here in Louisiana. Previously, if you were convicted of a nonviolent offense, you could get what was called good time or parole. And your parole eligibility on non-crimes of violence, generally on your first time, was somewhere in the area of doing 25% of that sentence. Your good time percentage on all nonviolent offenses prior to this new law was somewhere around the area of doing 35%. So that's how you get people accused of crime saying, do I get 2 for 1, 3 for 1? Well, basically, in Louisiana, there's no more 2 for 1, there's no more 3 for 1. If you do a crime now, you're going to do 85% of that sentence in jail.
Wow. Now, let me ask you, if a person committed a crime on yesterday, July 31st, 2024, or any time prior to that, do they fall under this 85%?
No. So they don't fall under this 85%. It's only for crimes that are committed today, August 1st, moving forward. They fall under this law.
All right. So if anybody has a family member or friend who's in jail right now, or even out on bond facing charges, they shouldn't be freaking out thinking they automatically have to do 85% because they fall under the old law. Is that right?
That's right, unless they committed a crime today and ended up in jail. Let's say they committed a crime at 12:01 last night, they SOL, they shouted up. You know, they should have moved that level. Should have moved it a couple minutes ahead or something.
Ah, gotcha. So let's go to the next one. If I can. I went too far. Let me go back. Parole is now restricted and eliminated in some cases. Tell us about that. So
previously, a person basically, by merely serving a sentence, at some point they were eligible automatically for parole, a parole release or a good time release. But with this new law of 85%, the governor is taking the position that people that committed crimes were getting participation trophies or participation for being in prison and just simply being released. So now parole is basically limited to certain situations, and you have to fall in a certain class of people and a certain class of crimes now in order to get parole. And in fact, in some cases, it's eliminated outright.
So if you commit a crime, don't count on parole because chances are it's not available.
Nah, it's probably not available. You probably got to do 80. You got to do 85. So, like I said previously, a non-crime of violence, you could have paroled out in some cases after 25% of the sentence. Now you got to do 85% of that sentence in order to get released on parole. And on some crimes, there's no parole at all.
Wow. So I would imagine that for, the criminal code is about as thick as you could imagine. So if somebody has multiple, depending on the crime, even an experienced criminal defense lawyer as yourself, you got to go look through the book and look at the statute to see when and if that person qualifies for parole.
Yeah. So it's going to take some time to make some adjustments. I think a lot of people are adjusting, and anybody that practices criminal defense law or you have a family member in the criminal system, it's going to take some time to get used to this. I believe this elimination of parole in good time and also doing 85% of sentences now, I think it's going to cause a backlog in criminal cases now because an inmate previously had an incentive to plead guilty and to accept responsibility for what the crime they were accused of. However, now, I think that is pretty much diminished. There's really no incentive in some cases to plead guilty now if you're going to have to do 85% of the sentence. I definitely disagree with these two new laws for those mere facts. I think that's going to require more jury trials. And I think that's in turn is going to burden the system that's already busting by, it seems now, due to the COVID backlog that we still haven't been able to get through.
So what are they going to do with all these people? I got questions like pretrial detainees, where are they going to house them? Inmates, where are they going to house them? If all these people are serving 85% of their prison term in jail, I mean, do we even have enough prisons in Louisiana, or is there going to be yet another boom in the prison system? Are we going to build more jails, more prisons? What are we going to do? Louisiana already has the highest incarceration rate in the world, higher than Russia, higher than China, as far as the percentage of our citizens who are incarcerated. So where are we going to put all these people?
I don't think the legislature, I don't think when they were making those decisions that they envisioned these problems. So I think I don't know where they're going to house these people at. Give me a 5.
All right, folks. Harry had to take a little break on us. We're gonna take a little. I'm gonna also pause everything for a minute. Play a couple of songs for y'all. How about that?
Elephant stomping in the courtroom, great elephant defending the innocent, mind sharper than a tenement, criminal defense game stronger than cement. Out here wrecking cases so your time may spent, suits clean as a glass, arguments intense, great elephant in go. Late nights grinding, paperwork and stacks. Great elephant, beat flexing facts. From the trenches to the marble floors, straight facts. Criminal defense, kingpin, never falling back. Trapping legal, heavy on the blocks. Great elephant, got the docket on lock. Courtroom like a jungle, keeping it non-stop. On the defense line, clapping at the clock.
Back?
Yeah, I'm back.
All right, so let's move on to the next slide in this slideshow. No more 2-for-1. So you kind of touched on that. What else can you tell us about it?
I just mean now you commit a crime. I guess I think young people especially that have no experience with the criminal justice system. I think you need to, ask yourself prior to committing a crime: are you prepared to, do 85% of whatever the sentence is of the crime that you're going to commit? It used to be, some people would take the position that I got to do 25% of the 10-year sentence, or I got to do a year, but now, it's pretty significant sentences that people now face. So, the good time law is just no longer in existence. It's no longer a thing.
All right, let's see what else we got. 17-year-olds are now considered adults. Tell us about this.
So, under our former governor, at some point, there was a law passed that allowed children who are 17 to have their cases if they committed a criminal act. Certain criminal acts are allowed to be stayed in juvenile court, in delinquency court. However, under this new law, if you're 17 years old and you commit a crime, you're going to be in adult court. You're going to be in district court. You're going to be facing the same penalties that an individual that's 37 years old, 27 years old, 47 years old and above will be facing. So now, they're not treating children as children any longer. And I think this is due to the influx of juveniles committing crimes. And I believe some people take the position that juveniles know that, I'm only facing a juvenile sentence. I'll either, get in trouble, go home in a couple of months, couple of years. There's no real consequences here because I'm a juvenile. And I think this is in direct response to the explosion of juvenile crimes, where there's carjacking, robberies, juveniles with guns, juveniles shooting people. So I think this is a responsive law. I don't think it's a good response to it. I think we've tried that already with juveniles, and it hasn't worked. Being tough on crime with juveniles hasn't worked. Being tough on crime with adults hasn't worked here in Louisiana, because if being tough on crime was a deterrent for people, a deterrent to deter people from committing crimes, we wouldn't have the highest incarceration rate. We wouldn't have so many people in jail if these laws actually act as a deterrent. There's a lot of studies out there that say juveniles and certain, specifically males that are under 25, that their brains haven't developed fully. That's why the law was in place to treat juveniles as kids, 17 years old, as kids, and not to treat them as adults, and not to hold them to the same standard that they would hold an adult to that committed the same offense.
It sounds to me like you don't think this is fair.
I don't think it's fair for a number of reasons. I think you have to think about it. Most people when you're 17, you're probably a senior in high school. You're not aware of what a crime is. Your I guess knowledge base or your point of reference, if you get in trouble, is generally you go to the principal's office. The principal either suspends you or gives you some kind of administrative sanction, whether it's in-school suspension. I don't think they do corporal punishment in schools anymore. So at the very least, that's your point of reference. But now you're telling 17 years old who merely, let's say, A 17-year-old had a prescription for Adderall, which a lot of young people do, and he has his Adderall. He takes his Adderall. Let's say he has a friend that says, "Hey, I want one of your Adderall. Can you give me one of your Adderalls? I don't have any. I'm out of mine." And that 17-year-old passes that Adderall to his friend. He just committed a distribution. He's not aware that that's a distribution. He's thinking, my friend needed some medicine. He has a prescription. He asked me for some, and I gave him some. But under the law, the plain reading of the law, that would be a distribution here in Louisiana.
All right, let's move on to the next one. Post-conviction relief is limited. So, first of all, what is post-conviction relief?
So, post-conviction relief is after you've went to trial, after you pled guilty, after your appeals have ran, you file. There's a procedure that allows a person to bring up issues that maybe could not have been brought up at the time of trial, or issues that they later found out. It could be in a version of newly discovered evidence. It could be prosecutorial misconduct. The prosecutor did something, withheld some evidence. The police officers withheld some evidence. The police officer threatened witnesses, or even in some cases, the defense attorney was not effective. In Louisiana law and also federal law, all defense attorneys that represent people accused of crimes are required to be what's called effective, provide effective representation under the Constitution. And what's happening here with this post-conviction relief is limited. Now what the law is saying that previously, if a person there's a 2-year window that a person has to file a post-conviction claim with information they have knowledge of at that point. But what we found from the Innocence Project and other agencies that handle a lot of post-conviction is that sometimes it takes a person's in prison, this information may not become aware of them until after that 2-year time period has ran. And in this case, the governor is now saying that in order for someone to file post-conviction, they have to to file post-conviction, you should just file the district court. You would serve the district attorney of that parish where you were convicted at. You could file, you had to serve them with a copy of it, and a judge at that point could either grant you a hearing on your motion, or he could deny it, or he could do various things. Or in some cases, the prosecutor could look at your post-conviction application and determine that, hey, this has some real merit to it. Whatever the case may be, maybe his defense lawyer was not effective, his defense lawyer didn't do an investigation, a prosecutor in my office did something that they shouldn't have. But in this case now, post-conviction, they're saying that it's limited because now you now have to also serve the Attorney General of Louisiana with your post-conviction application and put them on notice you're filing. So this somewhat eliminates the deal that a local prosecutor could make with a defendant in a lot of cases to give them some form of relief. The post-conviction laws are also limited now, is that it used to be there was a 2-year window that after the 2-year window, there were instances where you could file and bring your claim as to it. But there's also some limitations there now as well to further prohibit or place more burdens in. And basically, they're saying that once you're convicted, you're convicted. They're trying to keep the people in jail no matter what happened. They don't want to give them an opportunity to find these things to get released.
So it sounds to me like, and you correct me if I'm wrong, but the post-conviction relief application, post-conviction really comes into play to help people who have been failed by the system. Would that be fair to say?
Yeah, so failed by the system, whether it's failed by law enforcement, a prosecutor, or a defense attorney doing something wrong in their case. Something illegal happened that shouldn't have happened, and they're saying that now, we're going to limit it. And also it's limited in previously, once your 2-year window had ran, it would be was considered time barred. But under this new law, they're saying, and in previous cases, you could have the defendant and the prosecutor could have agreed that, hey, this has some merit, so we're going to waive the limitations of the 2-year window for you in this case. We're not going to do it in every case, but we're going to do it in this particular case because your case has some merit. And this new law, in some forms or fashion, prohibits those agreements from occurring between the prosecutor and the defendant and his defense attorney on their post-conviction application.
So a lot of sounds to me like there are a lot of innocent people in prison. We know that there are a lot of innocent people in prison, but when we talk about those innocent people in prison, and their innocence isn't discovered until 3, 5, 10, 15, 20, 30 years later, it sounds like it's going to be hard for them to get out, harder than it already is. When we know
it will be. There's the post-conviction process isn't an easy process. It takes a lot of work and it takes a lot of time sometimes to develop that. Sometimes to find these witnesses and they don't come forward for years and years. And if you even look at the inmates that are on death row, Louisiana at one point had the most people on death row, but at some point I think Louisiana also had the most death row exonerees from information coming later showing that a prosecutor did something previously that caused this person to be on death row, and they later found evidence that showed this person either didn't commit the crime or the person did commit the crime that they were accused of, and that gave them some kind of relief and got them off of death row. But this new law is probably going to keep more people in prison, more people on death row than we previously had.
Wow. So this needs to be remedied ASAP. Probably won't happen in the next 4 years with this governor, but something needs to be done about this, it sounds like. So let's see what else people need to be concerned about. All right, concealed weapons are permitted without a permit. So I don't have to go out and get my concealed weapon permit? That's what you're telling me?
Yeah, so this new law says that, in which I think is going to be a matter of interpretation. It says a person who's not breaking the law, a law-abiding citizen now can lawfully carry a concealed weapon without a permit. The issue becomes that what is law-abiding, right? And I think the issue becomes that even if you have a concealed weapon permit, you can't get intoxicated, right? So if you're carrying a concealed weapon and without a permit, or with a permit now, I believe you now expose yourself to potential criminal consequences by merely being intoxicated and carrying a concealed weapon. I think there's going to be some issues there. Also, if somebody has a little bit of marijuana with them, I don't think this law that they enacted, it didn't take into account several other laws. Additionally, now you have to be aware that a person who commits road rage, or you're at a store, somebody could be packing a gun, so you simply pushing your buggy down the aisle, and maybe you back the car into somebody's foot. They may be packing, and they may get angry and pull their gun out on you because they're upset that you simply ran over the back of their foot with a basket in a store, and they could walk in. So I think this law, this is a very scary law, I believe, in that you don't know who has a gun now. And I think the benefit of having to require a permit for a concealed weapon was that you had to take some kind of firearm training. You had to take a class that was 8 hours that taught you how to shoot, how to safely disarm a gun, how to break a gun down, how to clean it. So now this new law is taking that requirement away, and I think it presents some scary alternatives to now what we're going to have here in Louisiana. Basically, we're pretty much going to be the Wild Wild West.
So let me ask you a question, because we know now that a little bit of marijuana is a citation, and then there's a small amount under how many grams is a misdemeanor?
Under 14 grams.
All right, so let's say a guy has Tim. Let's say Tim. Tim has 13 grams of marijuana and a firearm on him. He's carrying a concealed weapon in one pocket, and he has 13 grams of marijuana in the other pocket. Misdemeanor marijuana and a firearm. Is that a problem? Are there any laws that make you pause?
Well, I think it should make you pause because I think it's still a legal carrying of a firearm because you have a legal firearm. And I think based on your hypothetical, we're assuming that Tim legally owns his gun. Whether he bought it himself, someone gave it to him, it's not stolen. He's not a convicted felon. He doesn't have an active restraining order or a previous restraining order. So Tim is legally carrying a gun. He's legally, he can lawfully carry a gun. In Tim's case, if he had the 13 grams of marijuana, I believe that law wasn't changed. So he's potentially facing a misdemeanor, what's called illegal carrying, because he has under 14 grams of marijuana and he has a firearm. While some people would argue, well, my gun is legal, the illegal marijuana, unless Tim has a prescription. I don't even know if the law even took that into account. That if I have a marijuana prescription and I have my gun, am I still breaking the law? So I don't think this law envisioned that that potential issue, but I think it becomes an issue that someone could get arrested, and not say they'll be convicted of it. But I don't know if there's any guidance that's been given to law enforcement to say, well, if somebody has a concealed weapon now and they have some marijuana, you need to verify whether or not that marijuana, because we know the concealed weapon is legal. And now we also know that people in Louisiana can get a recommendation for medical marijuana. And if this person has it, I don't know if that law took that into account. And so I think there could be some potential issues there.
So let's say a scenario a little different. Tim is lawfully carrying his firearm and he has more than 14 grams of marijuana, but he does not have a prescription.
Yeah, I think Tim is facing a potential felony charge. Let's change the drug a little bit. Let's say Tim has one lower tab of Adderall, he doesn't have a prescription for it. I believe Tim could potentially be prosecuted for illegal carrying of a weapon with a CDS, or controlled dangerous substance. I think Tim could still be prosecuted for that. Go ahead.
Just so our viewers are clear, if we look in the criminal code, there's a specific statute that a felony is illegal possession. What is it? Illegal possession of a firearm in the presence of a CDS?
Yeah, it's legal carrying of a firearm in the presence of a CDS, and that your firearm could be bought from any gun store. But if you have some illegal drugs, whether it's cocaine, marijuana, or more than a certain amount of marijuana, different pills, prescription pills that you don't have a prescription for, that makes a gun illegal. And previously, even if you had a concealed weapon permit, you couldn't be under the influence of alcohol or drugs that made you intoxicated. So I'm not sure if these newly enacted laws took into account all those different variables. So it'll be interesting to see how someone gets arrested, how this will be prosecuted.
It sounds to me like a setup almost. It's like there's going to be a lot of people who have no intent to commit any crimes, who don't have a criminal record, and they're taking two conceivably lawful things, combining them, and now they're facing a potential felony offense. It's almost as if the legislature just kind of had this knee-jerk reaction where they passed this law without looking at the other laws that work in conjunction with it.
Yeah, I think that happens a lot. That you have some people, legislators, making these laws that don't actually practice in criminal defense work. They don't understand that there's checks and balances, and there's I would say bricks that build on building blocks that build different bricks. That you have to take into account different variables. I don't think those variables were taken into account. Like I said, I think it'll be interesting to see how this all plays out. And I'm a Second Amendment guy. I believe in firearms, but I believe in possessing firearms legally, correctly, and safely. And I don't believe this new law takes into account that you're going to have a lot of inexperienced, emotionally unavailable individuals and individuals that can't control their emotions possessing a firearm now that could easily be set off by merely, as I said, the example I gave earlier, merely being at a shopping center and somebody doing something to them that they deem disrespectful or they deem that has escalated beyond a mere argument. This is a very scary law that now, you have to be real cautious of who you talk to in the store or in your surroundings, because now people just get in an argument and pull guns out now because they can legally carry a concealed weapon. And I'm real concerned about it. And I'm a card carrying member. I've been having my concealed weapon permit card probably for the last 3 years. Even with that, I rarely take my gun out of where I keep it at. Whether it's in the car, I just don't feel the need for it. Although I have a concealed weapon permit, I think to me that's very scary.
All right, let's see. I think that we got more. Skip one. All right, let's talk about this. You cannot come within 25 feet of a police officer conducting an investigation or working. What's this about?
So I truly believe this was some sort of a compromise, Chris. I think initially, the initial bill that was proposed was that they wanted to pass a law that said you could not record police officers. Imagine that in the United States of America, that they were trying to pass a law that said you could not lawfully record police officers who were conducting a lawful arrest or a police investigation. This definitely goes against everything we saw for the last 4 years with the George Floyds of the world, with the Michael Browns, and all these other cases where had it not been for some citizen recording the police illegal act, these individuals would have never been held accountable for their actions. So the compromise here was that they came up with this rule that said you can't go within 25 feet of a police officer's conducting an investigation or working, which I think to me is that's going to be another issue, one of those issues of how do we determine what does working mean, what does an investigation mean, and what happens if a person sees a police officer doing something wrong, and who determines the 25 feet? Because we have to remember that all police officers don't have body cam, right? So who's going to who's going to mark off the 25 feet for the police officer to say, hey, you can't come in this restricted area. This is a restricted area, So I think this was, in my mind, this was some law probably proposed by law enforcement that, to me, if you're in law enforcement, you shouldn't have a problem with being recorded by citizens if you're doing your job properly. But I think this is going to be a problematic law because it's going to be hard to determine what's the 25 feet and whose determination of it. How does a citizen know knowingly violate this law if I just see a police officer outside? How do I know he's working? Is working mean he's just on the clock? Does working mean he's actually involved in an investigation, actively arresting someone? What does an investigation mean? So all these words, I think, is going to present an issue that somebody's going to have to define what that means at some point. Some appellate court is going to have to determine, or the Louisiana Supreme Court is going to have to determine what does this law mean and how do we determine the 25 feet.
Well, and if I'm trying to picture 25 feet in my head, and I know there's 3 feet in a yard, and so a first down in football is 10 yards, which is 30 feet. So we got to be somewhere less than that. Sounds like we got to be about 8 feet away or 8 yards away, 2 yards from a first down in football. Now, if you're not familiar with football, and even if you are, I think in a real life scenario, that's going to be hard to determine. So let's see.
I think it's gonna be hard to determine. I think someone can find themselves being arrested merely for trying to video the police officers and getting within that 25 feet, because we don't really know who determines that 25 feet. What is that 25 feet based on? Is it from all officers, or is the officer actually conducting the arrest and the investigation, or if he has backup out there and they're listening, they're
10 feet away from him.
10 feet away
they're
from him.
10 feet away from the incident. Do you have to be 10 feet away from the officer who's 10 feet away from the incident? Or 10 feet away from the officer setting up the perimeter?
So
what do we do? Zoom in with our phones, take pictures of videos?
Yeah, I think it's going to be one of those laws that are going to be a matter of interpretation. Somebody's going to have to come in and interpret it, because I think it's one of those laws that wasn't not well thought out, and it's another reactive law, I believe, to shield law enforcement from further scrutiny that we saw here, even with the Alton Sterling here in Louisiana situation. We had somebody videotaping it and saw the cops murder Alton Sterling. In that case, that individual, from what I can tell on that camera, was pretty close. That individual would have been breaking the law by being that close to videoing it, based on this new law that was enacted.
Wow. So let's see what else is going on in the great state of Louisiana. I skipped one. Let me go back. I got the wrong image, but police can now arrest a driver of a motor vehicle who refuses to identify him or herself.
Well, refuses to provide his identity. This is a law that requires now. There were some instances where a person, you could refuse to identify yourself to law enforcement, but now this is saying that if you're a private citizen driving a motor vehicle, you now have to identify yourself, and if you refuse, now the law enforcement has the discretion to arrest you for failing to properly identify yourself, and to allow law enforcement to identify who you are.
All right, and I think we got one more to talk about. Selling fake prescription pills laced with fentanyl is now punishable by 10 to 40 years. 10 being the minimum, 40 being the max.
So what in this current fentanyl epidemic, what a lot of savvy drug dealers have been doing is that nobody wants to openly just buy fentanyl, right? Nobody's just saying, "Hey, I want some fentanyl," because the danger of it, right, is very dangerous. So what some savvy drug dealers have been doing is that they purchase pill presses, whether it's on Amazon from other countries or just locally. They purchase pill presses, and what they've been doing is pressing pills to falsely, identify as, let's say, a Loratab or a Xanax bar. And what they were doing is, instead of putting the actual drug in that pill to give somebody a high, they're lacing it with fentanyl to give the person some form of a high, and the person unknowingly is ingesting fentanyl, thinking maybe I bought this Loratab off the street from some guy that said he had Loratabs for cheap. Maybe I bought the Xanax bar from someone that told me they had Xanax bars for cheap, and this pill is now laced with fentanyl and potentially could kill you. And so this particular law, I think is another responsive law. I think we have enough laws in the book that punish fentanyl. I can agree that fentanyl is a very dangerous drug, and it has caused a lot of deaths of recent. But this is one of those laws now that if you're caught selling fake prescription pills, basically selling a counterfeit pill laced with fentanyl, you're facing up to 40 years in prison with a mandatory minimum of 10 years, which the judge and the prosecutor, you have to at least get 10 years. And if we go back to the first slide, that means if you got the minimum on this case, you're looking at roughly 8.5 years on a 10-year sentence on the minimum.
Well, I do criminal defense as well as you, but this is this is one that's on the books. I can't complain about it. I think we've gone through 9 different laws, and this is the one I actually do not disagree with. People are dropping like flies. There's all this fentanyl is coming in from China, and nothing is being done to stop it. And I think, they're just trying to save some of our citizens. Look, if somebody's gonna buy a drug, it'd be nice if they were getting what the hell they thought they were buying. Not that I'm in favor of people taking illegal prescription drugs that they don't have a script for, but look, if somebody thinks they're taking Loratab or oxycodone and they're taking fentanyl, that's a problem. Hospitals struggle to properly administer fentanyl. There's a lot of medical malpractice cases that occur because the doctors in the hospital with Narcan on the crash cart administer too much fentanyl to people. So of the 9, I'd say the legislature is 1 for 9. I would agree with this one. I have issues with all of the others I've seen. Hopefully we can flush them out and clean them up and clear them up over the next few years, because we have to do what's best for our citizens, and a lot of these laws are borderline barbaric, except for this one.
Yeah, I think there's no complaint. It's hard to complain against this law. We also have to remember that, advise the viewers that, the person, if you just sell it, this law right here is just saying if you sell it, you're caught selling it. But there's another penalty if you sell somebody a pill that's laced with fentanyl and they end up overdosing and dying. You're facing a life sentence on a second-degree murder case, because that's considered murder here in Louisiana, dispensing some narcotic that causes someone's death. And in this case, so this is just for selling it. And there's a whole other penalty if you actually distribute it and that person dies as a result of you distributing that drug.
All right, great. Well, I want to thank Harry for coming on. Even interfering with his fatherly duties to come on and join us and talk to us about some of the current laws that are taking effect August 1st, today. Once again, if you found this content useful, please like the video, go to YouTube, subscribe to Great Elephant Law. You can follow our law firm, Daniels in Washington. We're on Facebook, Instagram, YouTube, TikTok. We're all over the place. We also have our personal profiles. Mine is Great Elephant Law on Instagram, and just my name, Christopher Washington, on YouTube. On Facebook. How about you, Harry? What's your name on Instagram if they want to find you?
My Instagram name is Attorney Number 1. So they can find me there on Instagram, and if on Facebook, they can follow me at Harry Daniels III on Facebook, and also Champions for Justice on Instagram as well.
If y'all have any questions for us, feel free to leave a comment under the video or go find us on social media and DM us. We will try to continue this, hopefully on a weekly basis. That's the goal, but we do have a lot of trials. We try a lot of cases to juries. We have a lot of hearings in our criminal and civil matters, civil being personal injury. So if you need our legal advice or legal representation in any of those areas, don't hesitate to reach out. Have a good evening and peace. Anything you want to add, Harry? Nope, I guess not. He's off. All right, take care, folks.
Great elephant in the court, stomping ground, defending the innocent, justice.